One particular charge used to convict and indict hundreds of January 6 rioters may be thrown out. It's a real possibility after 2 hours of oral arguments at the Supreme Court today. So I'm going to tell you all about what this means in a second. But first, I want to thank my subscribers for voting for this story as the bonus this week. If you want to vote too, make sure you subscribe to my page during my next live event. Or you can always follow these steps and you can subscribe right now. Okay, here's what's going on. The justices heard arguments in the case Fisher versus the United States. Fisher is Joseph Fisher, a former police officer who was indicted on charges of assaulting a federal officer and entering or remaining in a restricted area on January 6th. But he was also charged with obstruction of an official proceeding for his alleged actions on January 6th. That crime carries a punishment of 20 years in prison. That former officer says the Department of Justice used an overly broad interpretation of the law when they charged him with that serious crime of obstruction and said because he did not take an action with respect to an actual document, record, or object in order to obstruct an official proceeding, he should not be charged with that crime. The thing is, the Justice Department has charged about 330 January 6 defendants with this same obstruction charge. 18 U.S.C. 1512-C, the law has been on the books for decades, and it has two parts. Part 1 talks about the crime of altering, destroying, mutilating, or concealing a record, document, or other object to attempt to do so with the intent to impair the object's integrity or availability for use in an official proceeding. Fisher said he didn't do that, so he should not be charged with that crime. But the Department of Justice says, not so fast. There's more to that statute that Fisher is choosing to ignore. The statute goes on to say, or otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. The DOJ says Part 2 of that statute is a catch-all for all the other actions used to obstruct an official proceeding, other than just tampering with a document or physical piece of evidence. Now, it's going to be up to the justices to decide whether DOJ's interpretation of that law is right or if Fisher's interpretation is right. If they side with Fisher and say DOJ, used an overly broad interpretation of the law, it's possible those 330 or so January 6 defendants who were similarly charged could see those charges dropped or have their convictions overturned. It's also possible that a few of former President Trump's charges in the federal election interference case being brought by Jack Smith may also be knocked out. Not all, just a few. The justices will issue a ruling in Fisher versus United States in late June.